Yes, Mr. Choudhury.
My Lord, I just have a couple of points I wish to address you on this morning. There was discussion yesterday about withdrawing a concession.
Yes.
And if I can just say that the appellant wished to argue on this appeal that the proper construction of Section 10 of the 1999 Act is that it only applies to contracts entered into between an individual civil servant and their respective departments.
Sorry, are we going to get this on paper?
I will send it to you on paper, my Lord, but yes, I just would need to read it out.
Okay, but I think if we're going to hear argument about it before we see it on paper, I need to see it. I need to have it at dictation speed.
Then I will.
My Lord, there won't be arguments, and we have seen it on paper.
They have seen the paper. There's no objection.
What if that's very helpful. But if Mr. Siegel has seen it on paper, why can't we?
Oh, my Lord, you can. I just need to
Okay.
make sure that there's a process.
Well, then let me just have it. Thank you, Mr. Siegel, for saying it's not an issue, but all the same, I better write it down. Wish to argue that Section 10
only applies to contracts.
Only applies to contracts
entered into between an individual civil servant and their respect.
Were you not told what's the judge's pen?
Sorry.
Sorry, that came out rather ruder than I meant, but between an individual civil servant and
their respective department for the first time after the 11th of May.
For the first time after 11th May 2000. Okay.
And then, my Lord, I seek to withdraw the concession made in oral submissions as reflected at paragraph 88 in Cox.
Yeah.
The withdrawal of this concession ought not to be unfair or cause any prejudice to the respondents, as no further evidence will be needed on this point.
Okay.
It is simply a matter of statutory construction. So I will arrange for a copy of.
Well, that's
helpful.
helpful.
To you, Lord, so you can look at it.
Now, Mr. Siegel, I think, has indicated that I better make it quite sure, and not across purposes, that you do not oppose the withdrawal of the concession.
I don't. I accept that it is a point of statutory construction, and therefore we can't be prejudiced, and we're not.
Thank you very much. Right, now, we to some extent anticipated substantive submissions on that yesterday, but do you want to say more?
I don't wish to say more than what was said yesterday.
Right.
That on the proper interpretation of Section 10, entering into a contract means entering into a contract for the first time.
Yes, thank you.
My Lord, and the second matter is, and I'm not making any further submissions because I've made the submissions yesterday. This is a question of how you deal with the matter on the appeal. Yesterday I made submissions on Section 2 and Section 3 of the 1999 Act.
Yes.
With respect to all of the cases.
Yes.
And the principles that apply will be the same to all three of the cases. And I invite you as a court to deal with Section 2 and Section 3 with respect to each of the cases.
Yeah.
However, I need to point out, in case the matter hasn't come through already, that in Smith, the HMRC case, the Mr. Justice Friedman case, the matter was raised and addressed in submissions, but he doesn't deal with it in the judgment.
Well, Section 2 and 3 was raised.
Section 2 and
the matter is Section 2 and 3 was raised.
Yes, it was argued out, but he doesn't deal with it because he says, I found there was no variation. And that's at paragraphs 121 to 123 of the judgment.
Yeah.
And the matter was not put in issue by either party in Cox.
Yeah.
But the evidence that is relevant to it was put before the court and findings were made. So there will be no further necessity to make findings at the High Court level. And there shouldn't be any prejudice to the parties if you do apply the principle across to the three cases.
Yes, so the only, what, is this the formal position? Quite sure what you're pointing out. It's not formally an issue in Cox because it wasn't raised.
Yes.
It was formally an issue in Smith, but wasn't dealt with. So formally it should have been dealt with by respondent's notice, which there isn't. But it is fully dealt with in Crane. Is that right?
Fully dealt with in Crane.
And so you're just really pointing out those two formal defects, but inviting them in so that in the present case they don't make any real difference.
Yes, that's how I'm seeking to put it. You will see that in Crane, the court addresses a number of submissions we did make about parts of Section 2, which apply if there is no consent. And we're not seeking to, because Section 2 can extinguish a right under the 1999 Act, even if no consent is given, if certain facts are found or certain conditions are satisfied. We're not relying on those. So to that extent, we're not appealing that part of the judgment. And that doesn't, and that would apply across the piece. The simple point is we say there was consent by the PCS to the variation for the reasons that I gave, or the reasons that I submitted yesterday. So insofar as you wish to go back to look at how it was analysed by Mr. Justice Choudhury in Crane, you don't need to concern yourself with the conditions point, because I'm not seeking to.
So which paragraphs of Crane do I no longer need to worry myself about?
So, my lord. Lord, the matter is picked up at paragraph 74, page 66 in Crane. Paragraph 78 is the point dealing with consent that we do challenge.
Yeah, you still rely on 78.
Yeah, but we don't rely on 79 because that is His Lordship's discussion of points 21A, section 21A, section 21B and section 21C of the Act, which is set out at paragraph 76.
Thank you.
My lord, that is all I have to say, unless there's anything further I can...
No, we may need to ponder the effect of the concession, but I think that's, or the withdrawal of the concession, exactly how it's framed, makes more sense, I think, to do that after we've heard from Mr. Siegel.
Thank you.
Can I just ask, have I understood this? Is the basis of the concession, or non-concession, that if there was a variation in any given case,
Yes.
then PCS was so integral to the facts that developed through the years
Yes.
that they should be taken as having consented?
Yes. That's the way it was argued in Crane,
Yes.
and that's how I was seeking to argue it
And that's
yesterday.
how you continue
Yes.
to put
And
it?
if you find there was a variation at the individual level, if PCS consented to that variation,
Yes.
then section 2
Yes.
knocks out their claim. That's
Need
how-
variation and consent.
There needs to
And
be
if you
variation
have
and
neither
consent.
of those, or only one of those, you lose.
That's not enough,
That's not enough.
and otherwise there's the waiver point.
Yeah.
And we either have that or we don't have
Oh,
that.
you don't, yep.
Thank you.
Thank you, my lord.
Again, we've no objection to that, my lords, although there was no need for a respondent's notice in Smith because the point wasn't taken on appeal in Smith. So that's,
I see.
as if effectively my learned friends are saying that they would like the point to be taken across all three cases, we've no objection.
Thank you.
My lords, can I start by clarifying points raised by the court at the beginning of the hearing by reference to the pleadings in the Smith and HMRC core bundle, page 57. While you're getting that, the pleadings are very similar, as you might imagine, in all cases. Towards the bottom of page 57 of that core bundle, you should find paragraph 8.1.
So sorry, you did give me the page.
57
57. Yep.
in Smith and HMRC core. So you'll see the last sentence of paragraph 8.1. The individual claimants seek a declaration.
I'm really, really sorry. It's entirely my fault. I thought you'd said Crane, so I went there, and I've now gone to Smith. But I'm really sorry. It's entirely my fault. I still haven't got the page. I'm really
57.
sorry. 57.
57.
Could you be very kind and refer to the cases of Smith, Crane and Cox rather than HMRC?
Yeah.
Absolutely.
Because habits die hard.
So, the individual claimants seek a declaration that the purported termination of their entitlement to have their PCS subscriptions collected by means of check-off amounted to a continuing breach of their contracts of employment and that they remain contractually entitled to have their trade union subscriptions collected by check-off after that date. So, the individual claimants allege a continuing breach of the failure of the employer to afford them what my Lord Justice Lewis referred to as the check-off facility. Then as regards PCS on the next page at 8.3, picking it up at the bottom of that first substantive paragraph, PCS is entitled to be compensated by the defendant for damages caused by, and then if you go to B, the like breach of that term of the contracts of PCS members employed by the defendant at the relevant date, whose circumstances were materially identical to any of the individual claimants as at that date, and to whose contracts the Act applied pursuant to the restriction contained within Section 10.2. So, a declaration that the Act applies to compensation for damage in respect of people who entered into contracts after 11th of May. I hope that clarifies the way the case is put, both the individual claimants and PCS. I propose first, my lords, to address the ground of appeal alleging that the individual claimants had agreed to
Just
vary.
an oddity. Particular claim not signed by counsel.
I hadn't noticed it, and therefore I can't explain it. It should have been. I thought it had.
Is it? Can we assume it's yourself and Mr. Patel?
You can.
Yes.
As I was saying, I propose first to address the variation point that the claimants, the individual claimants, had agreed to vary their contracts of employment by impliedly accepting the removal of their right to the check-off facility. Before doing so, there's a point on the scope of the defence on this issue. Can I ask you to look, please, at page 70 in the same bundle? Paragraph 17, it's pleaded that the claimants have affirmed their contract through ongoing performance and or waived any breach. And if you go to page 72 in the context of the PCS claim,
Just so far, I hadn't noticed this before. Affirm the contract. So what? I shouldn't perhaps be asking you, but that's.
I think
why is that a material? If it was being said that it was a fundamental breach and the contract would be brought to an end.
I think it was agreed below that affirmed was a misspeak, and consented to the variation was what was meant.
What I always find helpful is what state of affairs am I describing? Because the problem is people have used labels like there's no tomorrow, and have assumed that labels have the same, that what I understand by a label is the same as my laws will understand it. But it's always helpful to stop first and say, what state of affairs am I describing? And then to find an agreed label for that.
To be fair to my learned friends, I've taken you to the end of a paragraph which does contain some of what my lord would want to see. Also, the end of paragraph 20 of page 72, little d, if there has been a breach of contract by the defendant, the civil servants in materially identical circumstances to the individual claimants have affirmed, consented to the breach through their ongoing performance and or waived any breach. Now, the point I want to make is a short one.
Sorry, just before you make it, you think we're very pernickety. Do we have the last page of this defence? I was just looking at the same thing to see who signed the defence.
We don't.
It's not signed, but I think it may be because we don't actually have the last page.
Again, my lord's ahead of me in observing that. I haven't noticed it. But it was
Perhaps,
a complete...
Mr. Feeney, could you just check that the bundle? It's very likely that there was a final page with with boilerplate stuff in it and so on, including the signature of counsel. So could we see if we can get that? Okay. Yeah, you were about to make a more substantial point.
Yes, it's a short point. The only basis for pleading the consent, their mislabeled affirmation, was ongoing performance. There is no pleaded defence that some employees agreed to vary by not signing up to direct debits, but others who had signed up to direct debits had not agreed to vary, nor is there anything in the grounds of appeal, nor anything in my learned friend's skeleton to that effect. Of course, I only raise this because my learned friend did mention it as part of his argument orally yesterday. So we say that is not an issue before the court. I think to that extent my learned friend may agree, but nor do we accept, as he suggested, that it will be an argument available at the remedy stage to the appellant. So if you were to say anything in your judgments about that issue, we would wish you to say that. Turning to the substantive point.
It's an argument that's open on remedies.
That it's not. It's not a pleaded point. It's not one that... It would have had to have been determined at the liability stage. It's no longer open to the defendant at the remedy stage to say, we want you, the judge, now to make different findings on the issue of consent to variation, or additional findings than the ones that you have made. At the
You're not saying that they are prevented from arguing at the remedy stage if they get to it, that, for example, an individual's failure to sign up for direct debit, which you may characterise as a loss, is attributable to the individual's decision rather than to the breach of contract.
Of course, well, they can argue that, and they had in Kavanagh, and it was an argument that was recognised to be right in principle, that the account had to be taken at that possibility. Causation points, absolutely still open.
Sorry, I was being a bit slow.
So I then turn to the substantive point, which is, if I may quote Lord Justice Stuart-Smith, did the employees communicate an unequivocal acceptance, which is the question of fact. So not an easy finding to appeal. And I want to start by stating two propositions derived from the case law. The first is this: in no case has an employee been held impliedly to have accepted a detrimental change to their contractual terms. Let me restate that because it's important. There is not a single case in which the courts have found that an employee impliedly accepted a detrimental change to their contractual terms imposed by their employer. There have been several cases where the courts have held that changes imposed that are wholly or partly to the advantage of employees were impliedly accepted by them by their continuing to work for obvious reasons. They're not in your bundle of authorities, but some are referred to in Jones at paragraph 22, and the categories are referred to in particular by Sir Patrick Elias at paragraph 107 in Appellant. The second proposition is this. Where the courts have obiter considered the circumstances in which it might be possible to infer acceptance by employees of detrimental changes, it has always been on the assumption that there was no objection by the employees, never on the basis of the employees having objected to the change before it was imposed, even taking into account the mutual duty of trust and confidence in contracts of employment, to which I will refer.
Is that slightly overstating it? I seem to remember something in Judgment of Sir Patrick in Aberhall, where he says...
I'll be taking the call to...
well, we'll look at it when we get there.
Paragraph.
I'm sure you haven't overstated it, but I'd like to be reminded of exactly what he said.
No,
We'll see.
It's a very
I see what your
important
proposition
paragraph, paragraph 110, and I would respectfully suggest that the proposition that I have stated is entirely consistent with it. Now, the situations, my lords, in which there is neither express assent nor express objection from the employee are in practice rare. That's because in the real world of employee relations, employers do not tend suddenly to impose detrimental changes without prior consultation. Rather, they decide on what changes they want to make, they discuss those with the employees or their representatives with a view to reaching agreement, as in these cases. Might I underline the objections that were made in these cases on behalf of the employees by reference to a few of the written statements of those objections? There were, of course, meetings as well, which were not minuted, where PCS, on behalf of its members, made their objections orally. Can I take you, therefore, to a couple of pages in each of the supplementary bundles, starting with Cox. At page 115. You should, I hope, find in the second half of that page an email from Mr. Jones, of whose evidence were taken yesterday, the PCS officer, addressed
115, page 115.
115.
Thank you.
18th August.
Yep.
To the relevant manager, skipping the first sentence. I can report that I have done some members' meetings over the last week, and members' feedback from these is that they are completely against plans to deny them the option of continuing to pay their union subscriptions via the method they have chosen, and signed their membership form to that effect. It was also clear from these meetings that members were clear that they believed that this was a contractual agreement. We would like to continue to get further feedback from members. And then if you go on to page 123, there are more than these two or three in each case. I'm unashamedly picking the two most obvious. You should, I hope, find a letter of the 7th of October 2014 to the Permanent Secretary. I'm writing to you regarding the Home Office's decision to remove check-off arrangements, a decision which was communicated on the 1st of September following consultation process which disappointingly consisted of just one meeting. The decision by the Home Office to become the first civil service department to withdraw check-off is a further damaging blow to already strained industrial relations. PCS made it clear during consultation we view the move as a political attack. None of the reasons for withdrawal that the department set out in consultation changed that view. Skip a paragraph. We would therefore like to arrange an urgent meeting with you to review this decision. You go to the DEFRA, the Crane supplementary bundle, page 260. I hope you'll find a letter of the 15th of September 2014 to the Employee Relations Manager.
Crane 260.
260. I'm not going to read all of these letters, obviously, but to begin, PCS is opposed to the removal of check-off, believing it to be a political attack on trade unions. You appear to support this view by your statement that it is not desirable, this is the Cabinet Office's letter that you were referred to yesterday, my lords, that it is not desirable for DEFRA as a civil servant department to provide a service for, when I say the Cabinet Office letter, that phrase is taken from it, provide a service for an external organisation whose perspective is often at odds with our own. Next paragraph, skipping the first sentence. The civil service attaches importance to ensuring effective consultation and involvement of staff. Indeed, staff are encouraged to join an appropriate trade union and to play an active part within it. DEFRA encourages you to join and play an active role in your appropriate trade union. Then over the page, there are some bullet points. Second bullet point, would DEFRA consider retaining the facility if the unions offer to meet the cost? Third bullet point, our understanding is that some staff have a contractual right to have union subscriptions collected by Chekhov. Then at 263, sometime later, to the
we just see the reply to that. Is there an explicit reply in the bundle? Doesn't appear to be.
I don't know now. I did know once. I can't remember if it's the
don't worry.
next
Don't
page.
worry. It's just the flavour of it. Okay. Where are you taking us to? 263.
Yes, I mean in the context, obviously, of implicit consent, I'm focusing on PCS communications rather than government ones. But
No, I see that.
so 263.
But if the reply was tough, leave it or lump it, take it or leave it, and they take it, it might be relevant anyway. It's always hard to see things taken out of context.
Well, my lord, up to a point. I mean, I think if the reply had been take it or leave it, to which the response had been, okay, we'll take it, obviously, my learned friend would have drawn that to your attention. If there had been no reply, perhaps he would have drawn that to your attention. Those are counterfactuals.
Okay.
Page 263.
I mean, the correct answer is we don't have to take it or leave it. You are in breach of contract.
Yes, I mean, I'll come on to...
Yes, sorry, I'm just trying to see conceptually.
But of course, you will recall that all three appellants were adamant that what they were proposing was not a change to contractual entitlement.
Right.
So the language on both sides is often devoid of reference to contract. Not always, as you've already seen, but often.
Anyway, sorry, we've distracted you. You were showing us a passage on 263.
Not at all. 263. So, for instance, here's a good example. Under the heading 1, you see PCS remains opposed to the removal of Chekhov. They don't go on to say, comma, which we regard as a anticipatory breach of contract or something of that sort. And then the last bullet point, would therefore continue retaining the facilities if the union offered to meet the cost. Bearing in mind you've accepted the contractual right for a small group and the cost of continuing these arrangements is the same, PCS would be grateful if you could answer this question. I made that point for something that you'll be taken to later. And then finally, in the HMRC supplementary bundle,
I think you meant
sorry,
Smith.
the Smith supplementary bundle. It's page 85, or if you're working electronically, 89. Sorry, have I given you the right page number? Just bear with me one minute.
Letter dated 12th of January to Miss Homer.
Yes, sorry, I typed the wrong number into my computer. Yes, that's the one.
Well, I don't know about this. Is a section which, if your bundle was like mine, was conveniently placed in reverse order.
Well, I've got an electronic version, so it's in the right order.
Well, I suppose you could have done it in the electronic version as well. Just to make
True,
that really
true.
interesting.
But I was lucky.
Yes,
So you're looking
There
for
were
a
some
page which
problems
has
here.
85 on the bottom right.
yes, and as long as it's the letter, Miss.
It is.
Miss Homer.
It is.
Yeah.
And under the heading at the middle, PCS position on the future of Chekhov, second
Yeah.
paragraph. Our view remains Chekhov is a contractual right that's been employed without any problem for decades. Importantly, it's something that's seen as a key benefit by members, something they would prefer not to give up. And then in the middle of the next paragraph, you'll be aware the current arrangements are paid for by PCS at the rate of 50p per member per month. And then if you go to page 146,
Yes, I hadn't picked that up. So the answer is it was paid for in some departments and not others.
That's
depending
right.
On the particular arrangements made.
so HMRC paid, the other two didn't. But the point is that in both the other two cases, PCS said, look, if cost is the issue,
Yeah,
we will pay.
Yeah.
And in fact, the directive from on high long ago was each department is entitled to charge unions for the facility. So I think I was taking you to page 146, 150 if you're electronic. Second paragraph, we passed a copy of the letter dated 15th of January in which HMRC purports to inform our clients they will no longer be entitled to pay their union subscriptions by the end of that month. We take the view this constitutes an anticipatory breach of our client's contractual right, etc. This is the Thompson's letter that you've had a look at. So these are clear, unambiguous, written statements that the employees concerned object to, certainly do not agree to the proposed withdrawal of Chekhov. Now, in the general case, by the end of such a consultation process, either the parties will have agreed something, or, as here, they will have failed to agree, with the employees having made their position clear that they don't accept the proposed change. Now, in that situation, the employer has three options. It can accept that its proposed variation is not going to happen. It can dismiss the employees concerned with offers of employment on new varied terms, or, rarely, it can simply impose the variation and hope that the employees do not take legal action. It is in that last unusual situation that the time for talking, my lords, the time for consultation, the time for agreeing or objecting has passed. It's not only contrary to fundamental contractual principles, it is, from the perspective of real-world employment relations, absurd to expect employees or their representatives to continue a one-sided consultation process by repeating the objections they made to the variation when it was proposed, once the employer has terminated that process and imposed the change. And my lords, when, where, and for how long is it suggested that the unions in these cases should have pressed their members' objections once Chekhov had been removed? To take one point that my Lord Justice Lewis...
One simple answer might be, once it's actually happened, you write saying, we believe that this is a breach of contract. We reserve all our rights. Our members will be continuing to work because, say why because, but because it's not worth resigning over an issue like this. But they do so without prejudice to their legal rights. Now that's the pucker way of dealing with it.
That's the gold standard, and it was one that my Lord addressed, as did, I believe, Sir Patrick Elias in Aberhole, and the decision rightly, if I may say so with respect, was that is not required. But more importantly, you both pointed out, I believe, certainly my Lord Justice Underhill pointed out, it's something more of an ask when the employer is not presenting what it is doing as a change to contractual terms. But in all events, the case law, including Aberhole, makes clear that there is no requirement for that to happen. But I accept, of course, that is to use my Lord's adjective, the pucker approach. But leaving that to one side for the moment, and I was proposing to come back to it, and I will when I look at Appellant, but internally, as opposed to the formal statement of a reservation of legal rights, what is supposed to happen? The procedure for dealing with individual employee grievances is not an appropriate route. Can I take the court back to a page to which you were referred yesterday in the Cox supplementary bundle, page 142. You were taken to, I recall,
So sorry, so which page?
142. You were taken to a little bit of this page when my learned friend was attempting to address a question that my Lord Justice Lewis...
This was said to evidence the proper procedure.
Sorry, my lord.
This was said to evidence the proper procedure.
The proper grievance procedure, yeah.
What you weren't taken to were, I would suggest, the important parts of this page and the next. Starting at the top of that page, I can confirm the Home Office does not believe that it is under any contractual obligation to provide or continue to provide the check-off facility. Then, down towards the bottom of the page under the italicised bullet points. As such, in order for this matter to be dealt with under the Home Office collective grievance process, PCS would need to identify the individuals on whose behalf grievance is being brought. You were taken to that. Next page. In particular, sorry, I should have read the rest of that paragraph, my apologies. The sentence beginning second line from the bottom of the page. You should also be mindful of the grievance consideration test if you do pursue this issue under the collective grievance process. And in particular that grievances about policy content as distinct from the application of the policy will not pass the grievance consideration process. In other words, the employer, and this is not at all unusual, will not consider grievances. The grievance process is effectively, as probably you're all aware, certainly my Lord just Underhill very aware, is a process by which individual employees can make complaints about matters that affect them at work. The employer will not consider grievances about a decision or policy of general application. And remember, the appellants were maintaining this was a policy decision, not a change to contractual term. Instead, they will consider grievances about the application of such decisions in particular cases. So, for instance, you might have, not this case, but you might have a decision to require people to work till 6 o'clock instead of 5 o'clock. And Mrs. X might say, in my personal situation, that means I won't be able to care for my elderly mother or my child, so I want a relaxation of that in my case. That's what the grievance process is for. And obviously, the Home Office would not have permitted a grievance to the effect that it had withdrawn a contractual entitlement from its entire workforce, something it had already, as you saw, confirmed had not happened. They would not have allowed that to pass the grievance consideration threshold, and the appellants have never stated to the contrary. And that is why this grievance was not further pursued, and why grievances were not pursued in later cases. That's the grievance process. But more generally, my lord, employers and unions do not have regular catch-up meetings to gauge employee satisfaction with decisions that employers have already implemented.
Before you, I've accidentally turned over to page 141, and I just wondered whether you're relying on the bottom paragraph. I know that PCS believes that the decision to move check-off is a breach of its members' contracts, and that you state you are reserving your rights on this matter. So it appears that the Home Office thought, certainly at that stage, that you were reserving your contractual rights, not...
Oh, no. Absolutely, and that's... They're replying in that first paragraph I read to you, and maybe I should have made it express. They're replying to an assertion of contractual right and saying, no, we can confirm you're wrong about that.
Yeah, but you were actually, what you told them was that you were reserving your rights, not that you had rights only, but that you were reserving them.
Page 135.
Yeah. 135, sorry, I was looking at the wrong page.
Because we were saying, well, why didn't you write and reserve your rights? And this appears to indicate that you had. So that's the... and their rights are reserved in this respect, yes.
Yes.
Hang on 1 second. It's obviously where the reference is. Which is the bit where they say we reserve our rights?
Number 2.
Last paragraph.
And number 2.
Their rights in respect to that reserved. Yeah.
Yes, it's number 2. The last paragraph is a slightly separate point, my lord.
It's number 2, really.
It's another reservation of rights, but it's a specific point in terms of cost.
Just remind me when the Home Office one was withdrawn.
I believe the end of December.
Mr. Sheldon told us, and I've just forgotten.
1st of December.
So this was 4 days after it was withdrawn. I don't.
But I'm grateful, my lord, But I do want to make a more general point, because I think it is an important one, particularly when we get to this appellate level and the analysis is likely to range a little more widely in the first instance. Employees and unions, or employers and unions do not schedule meetings to gauge whether employees are satisfied with decisions employers have already implemented. And the question of check-off was not on the agenda at any meeting after the event. Now, is the union supposed to say at the next meeting, which might be to deal with hours or pay? By the way, our members continue to object to the removal of check-off. And if so, how often? If they did so once, or maybe twice, but then years went by before legal proceedings were instituted, would the employer's argument not be the same? Now, in which context, and I will obviously be taking the court to Underhill, but you may have in mind, though we say with respect my learned friend misinterprets the judgments in Underhill in this regard, the appellant's case had to be in front of this court and in front of the courts below, that Underhill could be distinguished, despite its obvious similarities in many ways, by reason, and it was made much more focused in this court by my learned friend yesterday, by reason of one factual feature to which he referred, which he said meant that the outcome was correctly different in Underhill from the one he argues for in this case. What was that factual feature? That after the first relevant pay date, one official from one of the three unions concerned, not the one incidentally representing the majority of the members, at a single meeting convened for another purpose a few weeks later, observed that his members had lost trust in the employer, who they saw as being in breach not of their members' contracts of employment, but of a collective agreement known as single status, which harmonised terms and conditions across local authorities. Now, when we go to Appellant, we'll in fact see that the court doesn't rely on that as a critical feature of their decision. But had they done so, I would respectfully suggest it would have been bizarre. They don't. But if the touchstone is to be that at some unrelated meeting, someone, as it were, recaps their distaste for what has happened, and that makes all the difference, the law would be an ass. Once the period of consultation is over and the change is implemented, a different industrial dynamic is in place and a different legal framework applies. And the question then becomes simply, do the employees sue their employer to reverse the change or obtain damages caused by its imposition? And if so, statute provides the timeframes within which such action must be taken. Now, we say that's also well established as an issue of principle, legal principle, and so obviously consistent with a common sense understanding of employment relations, it may be characterised as trite. So is there any jurisprudence which casts doubt on it? There is not. Indeed, prior to the Appellant case, our research, and I include my learned friends, has revealed only one case in which it has even been argued by an employer that its employees agreed to changes to their contractual terms to which they had objected before implementation, and that was Rigby and Ferodo, an argument which was brusquely dismissed by the courts, as we'll see. Now, for convenience, because Underhill deals with not just some, but all of the reported cases that touch on this issue, I was proposing to go straight to Underhill rather than to Rigby and Ferodo and Jones, etc., etc. So, in the authorities bundle, page 182, I start, as I know my Lord Justice Lewis would want me to, with the facts. Because my Lord Justice Underhill very helpfully summarises the key facts at paragraph 68. So these are quotes from the factual findings made by the first instance tribunal, internally, paragraphs 70.1 to 70.8. I'm not going to read them all, but the important ones really are these. 70.1 within paragraph 68. On a date, the employer informed the unions it was proposing to save money by an incremental pay freeze for 2 years. 70.2. The union strenuously opposed the proposals, including the pay freeze. 70.4. ACOS, a body of the council, decided to go ahead and implement the pay freeze with effect from the 1st of April. So in other words, there was a period between the 10th of December and the 8th of March when the parties were discussing whether it should happen or not, and on the 8th of March it was decided it would happen, and the first pay packet, it was agreed, would have been towards the end of April. And then in column 2, would you pick it up just above 70.7, which is the one comment that was made after the first pay check? There's a sentence beginning 4 words in. The second was at a similar meeting on 27th May 2011. A representative of Unite, the main union involved was Unison, Oz Taylor, said something along these lines. Colleagues feel they've lost trust in the council. Members feel they'd signed a legal agreement with the council in relation to single status, and the incremental pay freeze was in breach of that agreement. So that's the comment. And then the paragraphs which Justice Underhill rightly describes as crucial to the arguments before us because they were the ones relied on by the employer. 70.7. Not a single employee raised a grievance, whether individually or collectively. The unions did not raise a formal dispute. Neither was there any kind of industrial action. No letters were written by or on behalf of affected employees to the effect that they didn't accept the pay freeze or were working under protest or anything of that kind. Nothing was said or written by or on behalf of employees to the effect that they didn't accept it. Between that date and 2013, there was no further complaint by the unions, even an informal one, about the initial incremental pay freeze. In December 2012, the unions complained about a proposal to extend the pay freeze, but not the original 2-year pay freeze. The first post-May 2011 complaint was around April 2013. So those are the facts. Without wishing to oversimplify matters, the employer's argument in ABRA was that those facts set out at 70.7 and 70.8 had the effect of negating the effect of the objections described at 70.2. Then my Lord turned to review the case law. And again, it's important we understand the facts of the cases being discussed, at least in outline. Rigby and Ferodo, at paragraph 71 on the same page. The defendant sought to agree a 5% pay cut. Agreement did not prove possible, and they imposed the cut unilaterally. The union canvassed for industrial action, but notified the employers it wouldn't be taking action. It pursued an attempt through ACAS to achieve the restoration of the previous rate. In the meantime, the employees continued to work without making any individual protest. When conciliation failed after 5 months after the cut was imposed, about 5 months after the cut was imposed, one of the employees brought proceedings with the union's support. At first instance, Mr. Justice Ognall gave judgment for the employee. It's not reported, but it appears from the subsequent decisions that the employer's principal defence was that the employee had agreed to a variation of his contract, either as a result of things said or done by the union, by which he was bound, or by his own conduct, which appears to have been simply his conduct in continuing to work. That argument was rejected by Mr. Justice Ognall and was not pursued on appeal. So just pausing there, what was pursued on appeal was a different argument that we don't need to concern ourselves with. 73, the second part of the indented quote, there's a paragraph beginning, "It has been submitted." It has been submitted that there was some sort of, I should have said, I'm very sorry, this is from the speech of Lord Oliver. It has been submitted that there was some sort of implied acceptance on the part of Mr. Rigby of the appellant's repudiation by working on a At the trial, this was put on the basis of a stopper, waiver, and acquiescence. All three were rejected, and in my judgment, the judge was on the facts which he found quite plainly right to reject. I can, for my part, see no other basis on which it can be argued that the continued working by Mr. Rigby and his acceptance for the time being, and under protest of the wage, that the appellant, with full knowledge of his lack of agreement, chose to pay him, is to be construed as an acceptance by him either of the repudiation by the appellant of the original continuing contract or of the new terms which the appellant was seeking to impose. Now, we submit that the key words in paragraph 74 are with full knowledge of his lack of agreement, and that is what is meant, or at least that is all that needs to be meant by the words under protest, because you will recall there was no letter either from the individual or the union saying that they were continuing to work under protest. Towards the bottom of that page, the column ends with 3 lines from the bottom of this. However, Mr. Laddie emphasised...
Sorry, I've just been a bit slow to remember all this. Where does the phrase under protest appear?
It's if you read up from paragraph 74, it's the 7th line above. So the bit I just read within order.
Oh, and under protest. And your point is that
there was no formal protest.
There was no formal protest.
All Lord Oliver means, I suggest, although I am about to come to another possible interpretation that my Lord put on it, is in the full knowledge that he resisted that check.
Okay, so that is the question, isn't it? Protest is another word that we toss in. The state of affairs that has to exist is implied agreement. And if you know there's no implied agreement, whether it's because you shouted at him through the letterbox, I hate you, or whether you said, I really think this is a breach of contract, mate, you would say it's the same.
Well, it did occur to me that I could make my submissions much shorter by simply adopting my Lord Justice Stuart-Smith's observation that we needed to find an equivocal representation, and that was a question of fact.
Leave me out of it.
So, henceforth, that is now my fault, not my Lord. At the bottom of paragraph 74, in fairness, my Lord Justice Underhill says, however, Mr. Laddie emphasised that it was an express part of Lord Oliver's reasons for rejecting the protest that the employee had continued to work for the reduced wage only under protest. It doesn't seem that the protest referred to was any individual protest. Rather, it consisted in things said and done by the union at collective level. But it's clear that, unlike in the present case, the union had continued actively to oppose the cut through the ACAS machinery up to the date of issue of proceedings.
Yeah, you say that's me speculating, and you think that may be a more plausible speculation.
Well, I would respectfully submit, as my Lord suggests, that may not be what Lord had in mind. But the reason I say that is because pursuing an attempt through ACAS to achieve the restoration of the previous rate is not a protest. It's an attempt at conciliation, as noted at the end of paragraph 71.
Well, hang on. Conciliation is, in industrial relations terms, means negotiation.
Absolutely, but it implicitly accepts that there's no sound legal basis for challenge. If you think your employer has broken the law, has breached your contract, that's not when you turn up to ACAS.
Oh, no, that isn't right. I mean, you can't make, short of legal proceedings, which they eventually resort to, you can't make the employer pay more. And the process by which you have a series of meetings with them, I have no idea what they said, but no doubt trying to persuade them that this was may well have tried to persuade them it was a breach of contract. It'd be much better just to pay up now and avoid being taken to court. The idea that conciliation involves an acknowledgement that or is inconsistent with there being any breach doesn't seem to me to be right at all.
Well, I don't think it's inconsistent with, but it is certainly not a statement of your case that there is a breach. And it's certainly less confrontational than calling industrial action, for instance.
Oh, yeah, of course, yes.
Well, you say that, my Lord, but my Lord expressly holds later in this judgment that a failure by a union to call for industrial action cannot be interpreted as a change of position. So certainly a failure to go to ACAS couldn't be.
Well, I'm not actually quite sure what we're arguing about. A difficulty with Rigby and Ferodo is what exactly Lord Oliver meant by under protest, or with in circumstances where there wasn't a classic "I'm doing this without protest" letter. So I read it as meaning that the union's objection was counted as the protest. You suggest that it was the fact that he had communicated that he didn't agree. Neither actually quite works, because the point about under protest is you're actually effectively, it's in legal language more like without prejudice. I know I'm going on accepting less money than I'm entitled to. That doesn't mean that I actually think you're entitled to pay me less.
Which is the one thing that we know didn't happen.
Yes. Well, is it profitable to continue this point?
I developed this as far as I intended. The next case is Jones. Jones, again, the factual context is very important. Paragraph 75. In Jones, the employers asserted in a statutory statement of terms that the contract contained a mobility clause in wider terms that the employee considered to be the case. One of the arguments they raised was that the employee continued to work with knowledge that this was the term being asserted and therefore must be taken to have accepted it. So what was being considered there is the publication, without prior consultation, by the employer of a document purporting to set out a new contractual term. And it's in that context that Mr. Justice Brown-Wilkinson said, as per the indented passage, in our view, to imply an agreement to vary or to raise an estoppel against the employee on the grounds that he has not objected to a false record by the employers of the terms actually agreed is a course which should be adopted with great caution. If the variation relates to a matter which has immediate practical application, e.g. the rate of pay, and the employee continues to work without objection after effect has been given to the variation, then obviously it may well be taken to have impliedly agreed. So the context in which that obit comment is made is one in which the change is made without consultation and takes immediate effect, and the employee continues to work without objection. In that situation, it is said, he might be held implicitly to have agreed to the change. What the EAT was not considering was the normal case such as Rigby-Ferodo, Underhill, or the present cases, where the employer announces that it proposes to change the contractual terms and that the employee has an opportunity to object to their introduction for the future. Selectron is another case which doesn't fit the normal rubric of consultation prior to implementation. In Selectron, I'm trying to paraphrase a relatively complex factual situation quickly. The argument was that there had been an implicit acceptance that a contractual redundancy scheme was no longer enforceable because there had been occasions on which less advantageous redundancy payments had been made. I hope that's not oversimplified. But the passage in paragraph 77 over the page of the authorities bundle at internal paragraph 30 does not address the consultation then implementation after objection scenario. The fundamental question, Mr. Justice Elias said, is this: is the employer's conduct by continuing to work only referable to his having accepted the new terms imposed by the employer? That may sometimes be the case. For example, if an employer varies the contractual terms, for example, changing the wage or altering job duties, and the employees go along with that without protest, then in those circumstances it may be possible to infer that they have by their conduct after a period of time accepted the change. This assumes a sudden unilateral imposition of a detrimental change to something as fundamental as salary or job duties, and in such a situation the court held that the yardstick must be whether the decision to continue working is solely referable to an implicit acceptance of the change, and that will only be possible if inter alia the employee accepts the imposition of the change without protest. The last pre-Appellant case is Choudhury. It's a bit like Jones in that the employer simply stated in a written document, this time a letter, that detrimental changes were taking immediate effect. So paragraph 79, in Choudhury, the employee was sent a letter by his employer setting out changes to his terms and conditions as regards bonus and restrictive covenants. The terms, there were other changes as you'll see, but those are the two main. The terms had not been the subject of prior agreement or discussion. He was invited to sign a copy to signify acceptance. He didn't expressly object, nor did he sign the letter. He continued working as before. The relevant changes did not have an immediate impact, subject to something you're about to find out about. However, some 3 months later, having received notice of potential redundancy, he stated explicitly he was not accepting the new terms. Then, top of the next column, Mr. Gowdy, claimant, submits correctly, in my view, that none of the acts of either party unequivocally show acceptance by the claimant of the new terms. In reality, he carried on doing the old job for the same pay, as indeed did the individual claimant in this case, of course. The only difference was, and this is the one immediate impact, the only difference was in reporting to a different superior. That is a trivial difference, and miles away from a clear, unequivocal act from which one can infer that the claimant was accepting the new terms. Paragraph 46, it should be remembered here that not only did the new terms purport to remove the bonus entitlement, they also sought to impose restrictive covenants. Acceptance of the terms would make the claimant worse off. So why should his conduct, in continuing, just as if nothing had changed, spell out acceptance of this offer? And then the passage that was alluded to yesterday. We asked counsel for the employer when it could be said the offer was accepted. Was it the day after the offer? Was it when he accepted his first pay? Or when? Counsel could not really say, other than that the acceptance must have happened by October. That overlooks why he could not really say. It is because there is no unequivocal act implying acceptance. Paragraph 49, counsel submitted that this case is different because there was no protest. However, there was a failure to accept the terms, as specifically asked for by the employer. Why should anyone construe the fact of continued working as an acceptance of those terms? And then last paragraph, internally with the quote, applying Mr. Justice Elias's only referable test to the present case, it seemed clear it would be quite wrong to infer from the circumstances that the claimant had accepted changes to his contract, changes which were wholly to his disadvantage, both by removing the right to performance-related bonus and imposing restrictive covenants. There is no substance in the variation point. So in Choudhury, the only potential objection was implied from the employee's failure to sign a copy of the letter. It is, my lords, impossible not to characterise the extent and level of objections in the present case as much a fortiori. At paragraph 81, my Lord Justice Underhill notes 2 points of distinction with the facts of Underhill. First, as in the present cases, the employees were not asked to sign copies of letters in Underhill. To put it at its lowest, we submit that cuts both ways. The employees in Underhill were not required to agree the pay freeze, and the employees in the present cases were not required to agree the removal of check-off, because on both occasions, the employers presented the change as non-contractual, making it much harder, as both my Lord Justice Underhill and Sir Patrick Elias went on to hold in Underhill, making it much harder to infer acceptance by the employees. The second point of distinction my Lord noted was that the new terms in Choudhury did not bite immediately in the way that a pay cut does. That's obviously right, but in Choudhury, the employee was required to immediately report to a new manager, and arguably, that's at least as substantive a change as the employees in the present case being required on notice to pay union subscriptions by a different method. In short, we say, and this is the only decision of the Court of Appeal before Appellant, if Choudhury was rightly decided, and we respectfully say it was, it's hard to see how this court could reach a different conclusion in the present cases where, by way of the most starkly obvious contrast, the employees had repeatedly expressed through their representatives their objections to the proposed removal of check-off, and where, unlike in Choudhury, the employers did not present that removal as a contractual change requiring their agreement. Then over the page, my Lord identified certain principles or overarching propositions that he derived from the case law at paragraph 85 and 86. To take the position that to continue to work following contractual pay cut could never constitute acceptance would be contrary to the dicta in Jones and Selectron. A couple of lines down, a contractual offer can be accepted by conduct, and that must include the offer of variation. A few lines further down, I can see no reason why an employee's conduct in continuing to perform the contract in circumstances where the employer has made it clear that he wishes to modify, so that's not this case for a start, may not in principle be reasonably understood as indicating acceptance of the change. Going to 86, however, to say that in some circumstances continuing to work following contractual pay cut may be treated as acceptance doesn't mean it will always do so. On the contrary, what inferences can be drawn must depend on the particular circumstances of the case. Neither in Jones or Selectron do the judges go further than say that continuing to work might constitute acceptance. And then my Lord identifies certain principles for when continuing to work might indeed constitute acceptance in the following 3 paragraphs. First and foremost, the inference must arise unequivocally. If the conduct in continuing to work is capable of a different explanation, it cannot be treated as constituting acceptance. 88. Secondly, protest or objection at the collective level may be sufficient to negative any inference that by continuing to work, individual employees are accepting a reduction in their contractual entitlement. This is all in the context of a hypothetical pay reduction, or in this case, pay freeze, even if they themselves say nothing. Thirdly, the time issue. It's easy to see how it may not, depending on the circumstance of the particular case, be right to infer acceptance of a contractual pay cut as from the day that it is first implemented. The employee may be simply taking time to think. I'll come back to those words. And then at the bottom of that paragraph, I do not think that the difficulty in identifying the precise moment at which an employee should be treated as first accepting a contractual pay cut means that the question has to be answered once and for all at the point of implementation. And then turning to A187, so 2 pages of them, we get the ratio where my Lord applies those principles to facts of Underhill and notes.
Just will you give me one moment?
Of course.
I'm just looking, so you know what I'm doing, at para 100, which is where I identify what Mr. Laddie's main argument was. Yep, thank you.
And then at the end of paragraph 101, my Lord says there are 3 points that seemed to me particularly important. Before we read them, all of them apply with equal force in the present case. First, the proposed variation was wholly disadvantageous. You can read on, but that's the nub of it. The explanation that follows as to why that's relevant. Secondly, paragraph 103, the matter was not put to the employees as something on which their agreement was required. Indeed, given that pay was negotiated collectively, it was not something on which employees would normally be expected to take individual decisions, as here. Although that route had to be resorted to for the introduction of single status, it was wholly exceptional. No doubt, sorry, I should, for those who don't understand that reference, there was a fire and rehire situation where employees were asked to sign the new contracts in this case. Well, maybe I shouldn't have bothered to explain it, just in case.
I think all you need to, that particular point about single status is just a fact-specific case, another issue in the case.
Exactly. Yeah, exactly. It was wholly exceptional. No doubt when the freeze was first proposed, the council tried to get the union's consent. When that was not forthcoming, it was imposed unilaterally. And the council's position was it was contractually entitled to take that course. This is, in my view, important. Although I've been critical of the unions for not stating their position explicitly or encouraging their members to do so, the same criticism can be advanced of the council. It would have been open to it to tell the employees in terms that if they continued to work, they would be taken to have agreed to the proposed freeze, without prejudice to whether their agreement was legally required. I do not say that continuing to work in the face of a unilateral ultimatum of that kind would automatically constitute acceptance, but it would have made the Council's position clear and made the argument for acceptance by conduct stronger. There was equivocality on both sides. Thirdly, there was strenuous protest on the part of the unions, not only up to, but, and then this is the point about Mr. Oz Taylor on the 27th of May, beyond the date of the implementation of the pay freeze. To recap, sorry, I've not read perhaps the most important part, which is the next column. Still within the same paragraph, the last sort of 12 or so lines after the citation from Rigby and Feroda. There is no suggestion that the unions made it clear that they would take no further steps, still less that they would now reluctantly agree to the freeze. Indeed, the statements recorded at paragraph 70.6, including that of Mr. Oz Taylor, general though their terms may be, are inconsistent with any such volte-face. I do not believe that the failure of the unions to take further steps thereafter, or of the claimants to voice any explicit protest, compel the conclusion that their position changed. That is, with respect, the nub of the matter. So to recap, variation was wholly disadvantageous to the employees. It was not put to them as a variation. There was clear protest at the collective level prior to the implementation of the variation in the first pay check. We would submit that the combination of the first and the third factors, wholly disadvantageous, express objection prior to the event, are sufficient in any case to refute acceptance on the part of employees, who we contend should never be held to have accepted a purely detrimental change to which they have clearly objected, unless, perhaps, no such case has yet come to the court. There is equally clear evidence of what my lord referred to as a volte-face, or changed position. And the short judgment of Sir Patrick Elias takes the same approach. Paragraph 110, beginning at the very bottom of the same page. It may be said that the employee should never be held to have accepted a variation simply by working without protest under the new terms without more. After all, a party can bring a claim for breach of contract within the limitation period without having to notify the other party that he objects to the breach. Why should this be different? I think the answer lies in the fact that the employment relationship is typically a continuing relationship based on good faith. And if you would metaphorically or literally underline these next 5 or 6 lines, please. Exceptionally in that context, it might be appropriate to infer that a failure to complain about a proposed variation of contract for the future may be taken as agreement to that variation which prevents it constituting a breach. So that addresses, the first part of the paragraph addresses the paradigm situation, unlikely that it may be, where there's no objection taken by the employees to the change. But we respectfully accept the proposition I've just read out, that if an employer proposes a detrimental change to the contract for the future, to which the employees concerned make no individual collective complaint or protest, it might, in exceptional circumstances, be possible to infer their acceptance of that change. And it is in that context only that the continuing relationship of good faith forms part of the potentially relevant background.
Why should that be? Why should it be limited to objection in advance because of the complex nature of an employment relationship?
Sorry, I'm saying it's limited to situations where there is no objection.
Yes, I understood you to be taking the point that Sir Patrick is talking about, specifically a situation where there's an opportunity for objection in advance of imposition and no objection is taken.
Yes.
And I was just asking, what is it about the complex nature of the employment relationship that makes that a circumstance where you might infer acceptance?
Well, I'm tempted to say turn to your left, my lord, but I will be saying that the potential relevance of that factor is very slight indeed, and it certainly can never be determinative. But I have to accept that both my Lord Justice Underhill and my Lord Sir Patrick Elias do mention it as a potentially relevant factor. And as my Lord Justice Underhill noted yesterday, that was by way of the non-acceptance of submissions made by myself on behalf of the employees in Appellant, and as I shall explain in a moment, I stick to that position. But I can see, well, can I develop it?
Well, I think if you read the rest of the paragraph, it becomes clear really what he's saying at. The alternative would be to push people to the edge and dismiss and rehire. And they're saying there may be a kind of grey area, you discuss it in advance, and it's left hanging, and you might say, yeah, they've given and they've agreed. You don't, as the employer, have to push them to the edge. It's all in that context, I think. You've got to read the whole thing.
Yes, no, I mean, I accept what I took my Lord Justice saying is, do you need that factor, as it were, or would it be just the same in that situation without the implied duty of trust and confidence or good faith? Well, and I would suggest that generally that is not going to tip the balance, but I have to accept that on the authority of Appellant it might.
Yeah, but the factor I'm saying that he had in mind is that in a continuing relationship, what the employer would do is terminate and rehire. And that's the thing that can happen in an employment relationship. And Sir Patrick was saying, we don't want to push people to the nuclear option. And if there's discussion in advance, and exceptionally they don't say no, then there may be cases where, given that the union and the employer will know that they haven't been pushed to the end extreme of dismissal, that they might have compromised on a halfway house in between.
I absolutely agree. All I'm saying is, almost against myself in a hypothetical case that's never reached the court, I don't know that you would need the ongoing duty of good faith. If an employer says to employees, we are proposing that from 3 months' time, there will be a 1% pay cut, and we invite you to talk to us about that, make any objections if you have any, and they don't, and then the pay cut is imposed and they work on. I would say in that situation, the court is likely to infer acceptance, unequivocal acceptance, regardless of the background of the implied duty of good faith. But as I say, that case is so counterfactual to what happens in real life that it will probably never happen. But if it did, then to answer...
Well, you said, of course, it's like... I mean, your purist position, which you advanced in Aberhall and would like to advance here if you could, would say, no, why does the employee going on working after a pay cut, which they have refused to accept, mean that they have accepted a variation?
But my lord,
they've rejected. I misunderstood your situation.
Yes,
no, but you inserted which they have refused to accept.
I may have misunderstood. I thought you said, and they said no.
No.
Oh, well, I misheard your example.
No, the example that my Lord Justice Lewis and I were canvassing was where the proposal was made, there was no resistance or objection.
Well, in that case, I misheard what you
and
saying.
there I would say it would possibly, maybe probably, be the case that one could infer an unequivocal representation.
One can conceive of a set of those circumstances where the court might draw the conclusion that it's an unequivocal acceptance.
Exactly. And can I just...
I think what's apparent, looking at it again, is that both Sir Patrick and I, one wanted to reflect the effect of two previous EAT decisions, albeit obiter, but clearly considered obiter. But also just wanted to keep everything open for the future to be decided on a case-by-case basis. And I think trying to read the runes about what we would have said in a different situation, beyond the broad statements of principle, is not a helpful exercise. We were both clearly thinking it all depends.
Well, my Lord Justice, and I entirely accept that, but it's not just reading the rules. I will come back to, and if I may, I'll do it in this order, but I will come back to the most important paragraph and sentence, which is the last one, which we haven't got to yet, because that's actually the ratio of the judgment. So there's no rules needing to be read there. But before I do, can I just finish what I wanted to say on the trust and confidence point? Because, like my lords, I also have in mind that this is not going to potentially be the last case in which the issue is ever raised. So can I just ask you to look, keep, if you would, that page of that bundle open, but could I just take you quickly to the core bundle in Crane at paragraph 59.
Page?
Sorry, page 59 is what I meant to say. And there you should have paragraph 53. And my learned friend took you yesterday to a part of this, but again, I respect.
Sorry, again, I'm behind. Which bundle? Supplement. There's supplemental or core. Yeah. Which page?
59. It begins with an indented quote.
Oh, I see. This is Mr. Justice Choudhury's judgment.
Is.
Yep.
So in the third line of that indented quote, once PCS had made its objection clear, and I find it did in this case, nothing was done or said that would have unequivocally indicated to the defendant the objection was being withdrawn. That's Mr. Justice Choudhury quoting from his judgment in Collins. Then 53. That analysis applies in the present case too. The position might have been otherwise had there not been any protest or any ongoing litigation pursued over the identical entitlement against another government department. An employee who is in a continuing relationship based on mutual trust and confidence cannot ordinarily expect to continue working for lengthy periods approaching the limitation period for a contractual claim without being taken to have accepted a contractual variation. That was only the last sentence my learned friend read, and unfortunately, out of context. All that Mr. Justice Choudhury is saying there is exactly what Sir Patrick Elias is saying in paragraph 110 of Appellant, namely that where the employee has not made their objection clear, then continuing to work, etc., potentially brings into play mutual trust and confidence. So, I hope not too flippantly, we would encourage my Lord Justice Stuart-Smith not to be unduly intimidated. Two of the previous ex-presidents of the Employment Appeal Tribunal expressly limit the relevance of the duty of good faith to situations where the employees have made no objection. And my Lord Justice Underhill must be taken to have been of the same view, since whilst not saying so expressly, he didn't consider a matter which should affect the result in the other sort of circumstance. But to nail my colours to the mast, we do say that, with all respect, the duty of good faith is not a very relevant and certainly not a determinative factor, even where there has been no objection. Although, as I say, that case is rare if it exists at all. And I do just mention that employment contracts are not the only ones where the law insists on a continuing obligation of good faith. Is an insured who does not complain immediately about a breach of an ongoing insurance contract, or an agent who does not complain immediately about a breach by his principal of an ongoing agency contract, to be said to have consented to the breach? If so, the law will have to be rewritten in those areas.
By the way, you shouldn't, I think, paraphrase the duty of trust and confidence as a duty of good faith. They're subtly different, but importantly different concepts.
But I mean, for instance, I'm an expert in only two areas of law, if at all. One is employment law, the other is commercial agency. In commercial agency contracts, statute, never mind the common law, imposes a duty for each party to act towards the other in good faith.
You seem to be saying that if there's complete silence in a situation where you expect somebody, because they're working together, to say what they think, that's one thing. But when you've said it once, you don't have to keep saying it.
That's certainly the main point. But even complete silence, all I'm saying, as it were,
Actually, I see Sir Patrick did use the phrase good faith, which...
Based on good faith, he said, yeah.
But I don't think either of us actually expressly referred to... I mean, it's Mr. Sheldon who sort of bigged this up into an argument based on the Malik duty, if I can use that shorthand.
I agree. But
the point I was making in whichever paragraph it was simply this is an ongoing relationship which is constantly modified one way and another, and where expectations may arise, so we don't of how you would behave. Which are analogous to, though not the same as, the creation of a duty to speak.
It would be absurd for me to try and tell my lord what you meant.
Well, remind me what I said, and then I'll tell you whether I'm really...
Whether you meant it.
It does not appear to me now as it appears to appear to be then.
85 is the one that I believe my lord has in mind, where you refer to under a contract of employment in the 8th line, the parties are a complex relationship in which they are both required to perform their mutual obligations on a continuous basis, frequently modified by their conduct towards each other.
Yes, I mean, I think I could have... that is what I meant, but I think forced by the helpful presence of a proper contract lawyer on my right, to spell out why it matters, it is, as I tried to put it yesterday and put it just now, that it may create a situation in which there is something like a duty to speak, so that silence ceases to be mere silence. And whether that is so in any particular case depends on the particular case.
And as you've all pointed out very politely, I don't need to go that far in this case, so I'll leave it at that. Because the central point is none of this matters where there has been clear, unequivocal objection, and there is not a single piece of obiter in any case to suggest otherwise. But can I finish with the most unequivocal representation, that of Sir Patrick Elias, paragraph 111, where he turns to the facts of Appellant. And he records, as did my lord, the matter on which the employer in that case relied, a period of 2 years without complaint, during which, although there was no actual reduction in salary, the pay increments were not awarded. However, in the critical passage, which my learned friend, I believe, didn't take you to, the ratio, he was not persuaded that this could be construed as implied acceptance. I begin 5 lines in. However, I agree with Justice Underhill that the judge was entitled to take the view he did. There was initially objection to the change. Thereafter, once the decision not to take industrial action had been taken, neither the unions nor the employees nor neither the unions, the employees, nor the employer clarified their position. It could not, in these circumstances, be said that the employees had unequivocally, by their contract, shifted their position and accepted the new terms. So, in light of well-established contractual principles, a common-sense appreciation of industrial relations in a unionised workplace, and the analysis of the judgments in Underhill, with both of which Lord Justice Ryder agreed, we hope the court will understand why we continue to say that the appellants take a very bad point by this ground of appeal. My lords, I was going to, but do not have to, take the court to, I was going to take them to the last of the 3 judgments below to show that they apply the correct principles unexceptionally to the relevant facts. I can do that relatively quickly, but it will take 5 or 10 minutes. If it will be useful, I will do that. If not,
I'm content.
Sorry?
I honestly don't think you need. We see what your case is, and in substance that the judges agree with it, even if they put it slightly differently.
Then I'll just make 2, I think, short points. One is the importance of the time point that my lords raised with my learned friend yesterday. At what point in time, or within what period of time? And we say that the appellants throughout this litigation have confused or conflated two different concepts. The first is the period of time within which the employees may conduct themselves so as impliedly to communicate consent to an imposed variation. And secondly, the applicable limitation period within which they can claim breach of contract. And the first period will always be relatively short. That's why I took the court a moment ago to the part of Lord Justice Underhill's judgment in Appellant at paragraph 89, where he says it will likely equate to the period within which the employee may be simply taking time to think. Whereas the second period prescribed by statute is, of course, 6 years and applies equally to employment contracts. So the answer to the question, when did they communicate their unequivocal acceptance, must be within a few weeks or not at all. The second specific point, which I've dealt with to some extent in answer to the question of my Lord Justice Underhill, is that opposition to a contractual change post-implementation, my learned friends say, must include a statement that continued performance is without prejudice to contractual rights. Now, when my learned friend began developing that submission yesterday, my Lord Justice Underhill said it can't be right, and it wasn't pursued much further, but to the extent that it is formally pursued, we say it is unsupported by and contrary to authority, including Underhill. But more particularly, even if that was something that the court might weigh in the balance, in some cases, it would be very wrong to do so in this sort of case, as it would have been in Appellant, where the employer maintains that it is not making changes to contractual entitlements. Why should the employer be entitled to make a change under the pretext of the entitlement not being contractual, but the employee be required to object in strictly legalistic terms? And as Appellant implies, there is no good answer to that question. That was what I proposed to say about variation. I was now
Can we just I just raise one point. Intuitively, it is clear that both Sir Patrick and I and Aberhall were uncomfortable with the idea that the employee could simply go on working without indicating. Let's assume the situation was more extreme than it was. There are the features that enabled us to uphold the judge's decision. But when an employee faced with what is clearly a breach, and maybe they say at the time is a breach, just does nothing about it, maybe, as we're told in these proceedings, actually threatens proceedings, as I think they did in Smith, and then does nothing about it for 5 years. There's an intuitive feeling that the employer is entitled to expect that they're not going to do anything about it, and therefore to believe that they have accepted the change. Now, you've given many specific reasons which may well give you a complete answer in this case. But is there anything more you want to say about just the relevance of passage of time within the limitation period? I mean, do you take the absolute position that they could have indeed have gone on, as they very nearly did in these cases, to the 364th day of the 6-year period, and like any other legal rights, it doesn't matter what the other party thought you were going to do because you hadn't done anything before. It's just tough if they just change their mind and decide to do something at the end.
My Lord,
Or is your position more nuanced?
no, my Lord, it's common ground. When my Lord asked my learned friend, so when did they accept? He gave you 4 possibilities, as I recall.
Yes.
The last of which, unless I'm misremembering, and I invite him to rise to tell me if I am, because I'm quite capable of misremembering, but the last in time of which was when the result in Cabinet became known, which was, roughly speaking, just under 2 years after the event. So it's common ground. There has to be a factual circumstance or set of factual circumstances that entitles a court to infer an unequivocal representation. The mere passage of time, it is common ground, does not do that. So whether it's accepting your first paycheck without having made objection, or knowing about a result in another case and then not getting on with it, I mean, we say that that's a misconceived potential candidate, but it is a potential candidate as advanced by my learned friend. There has to be something. So no, I eschew any charge of nuance in regard to the passage of time. If there is no unequivocal representation, whether it's an agency contract, whether it's an employment contract, whether it's a commercial contract, you've got 6 years. And the fact that you're an employee makes no difference to that. The only relevance, potential relevance, I don't want to go over the ground we've canvassed at some length, but the only potential relevance of your being an employee is that you might be able to say that after the time to think has passed, in circumstances where there has been no prior objection, or at least no volte-face following a prior objection, then you might be able to say that by continuing to work at that moment or around that moment, there is an unequivocal representation. But if there isn't, if there hasn't, in this case, for instance, been an unequivocal representation by the end of month 1 plus, so either 1.5 or month 2, then absolutely there's no possibility of one having occurred at any later date.
If the employer breaks the contract and the employer is the wrongdoer, he takes the risk that he'll be sued within time. If he wants to avoid that, he has himself to press the nuclear option and saying, I'm terminating you and re-employing.
Or, as I think it was Lord Justice Underhill pointed out, the employer can take steps to ensure that silence is meaningful.
Well, it can do
the
that.
employer can say to the employees, we are going to start paying you at a lesser rate in 3 months' time unless you object in this way by this date. I'm not saying that would necessarily work, but at least then silence has some implicit meaning.
Yeah, and you could imagine situations where a year or two down the line, perhaps changes are made to a pay structure or something, or which only makes sense if the de facto situation, the breach situation, is in fact accepted by the employees to be lawful.
Absolutely.
Then there might be an estoppel or whatever. But again, that's not this kind of case.
No, I mean that's the more recherche example of the more common. I'll dock your pay, but you get Fridays off. If there's a quid pro the quo, either at the time or
well, I wasn't quite thinking of that sort of situation, but it doesn't matter. I think you could have all sorts of circumstances, perhaps, or you could have some circumstances anyway, in which an employee does agree to something which only makes sense on the basis that they have ceased to object to the previous breach. But we don't need to go there.
No, I mean, I imagine it will be difficult. I'm not proposing to do so. I imagine it will be difficult to construct that example unless the subsequent changes to the employee's advantage. So I'm docking your pay 1%, and then 2 months later I'm docking your pay another 1%. I don't think that helps. That the 1% is on the new pay rate.
Maybe. Okay. That's all I wanted to ask about. So we don't know, and I think it follows that it was never necessary for you to advance a positive case as to why, once Kavanagh had been decided and settled, there was not a sudden flurry of other cases brought or supported by the PCS for another, however many years it was, 3 years.
There is some.
But judicially, it can't be an indication of unequivocal acceptance to the breach not being a breach when you've won. Sorry, not the answer to that? Or?
No, I mean, I'm trying to remember and not being able to. There was some evidence in the statements of, I think, particularly Mr. O'Connor in the 3 cases as to what the union understood the position would be after Kavanagh. And if I'm misremembering, I apologise, but I seem to recall that the idea was there would no longer be any dispute.
It must become apparent in less than 3 years that there was a dispute.
Well, I think
It
that
does-
friend
I mean,
would
but
rightly
the answer-
say it wasn't raised with them, so they had no opportunity to either dispute it or not.
But the question is whether the employees in these three cases have unequivocally agreed to a change. Now, if they haven't agreed to it before Kavanagh, and if Kavanagh says in another department, in fact, it is a breach, well, why wouldn't they, and why doesn't that support the view that they're right, rather than say, well, now they haven't done something, they would be in effect punished for not doing anything. It seems odd to say that a victory in another case is an indication of agreement to the very opposite in their case.
Yes, my lord, maybe I was too quick when I simply dismissed that argument as misconceived. But why I say it's misconceived, partly for the reason my lord gives, but partly because I don't see how that impacts on the statute of limitation period.
No.
Well, it's got to impact on acceptors. The fact
Exactly.
that those people in that case have won and have been vindicated on exactly the same thing you are saying, and then you still don't take immediate action, is in some way an indication that they think, yes, I was right all along, but I don't mind, I've now accepted the status quo. That would have to be the kind of incorrect thinking.
But the short answer to my Lord Justice Underhill's case, question is I can't remember exactly what.
Well, there are no findings, and if there was evidence, anyway, there we are. On your case, it's irrelevant. You could have had a thoroughly bad reason, or no reason at all for the delay, just incompetence or whatever. As long as it's within the limitation period, as long as the employees haven't accepted, there it is. Okay.
Just 1 second, I'm being.
Can I just ask a question?
Of course.
Oh yes, that is a very good point that I had forgotten. The liability decision in Kavanagh was in May 2016. Remedy was not resolved until over 2 years later, and it was remedy that was going to inform the basis on which PCS said to another department, we think you might owe us of the order of £100,000 or £800,000 or whatever. So that explained the largest part of it. It wouldn't have explained all of it in some of the cases.
What was the date of the settlement? It was 2 years later, was it? So,
November 2018.
Just as well, you've got a junior and a team behind you.
Yes, well, I have
I've
junior
forgotten that. I've
instructor
forgotten,
and a witness, so I can't go wrong.
I've forgotten that the thing hadn't been settled either. The figures hadn't been worked
I
out.
was there at the settlement, so I should have.
Yeah.
my lord would like to ask something.
I've got two clarificatory questions. Your last point on the importance of time, submitting as you do in your written submissions, that the appellants conflate the time alleged to evidence consent and the period of limitation. And you say the first period, so that's the time alleged to evidence consent, will be short. Is that because there's no qualitatively different conduct thereafter to show a shift in position?
Yes, I think, if I may say, with respect, my Lord Justice Underhill's analysis must be correct. Namely, if you're going to infer assent at all, then as pleaded in the defence, it is the continuation to work. Not, we say, on these sorts of facts, but in another case perhaps. And all my Lord Justice Underhill said, rightly, I would suggest, is that continuing to work might have to mean continuing to work for long enough for that continuation to be meaningful. In other words, having had sufficient time to think, having had the next pay packet perhaps. So I would not put the position as it's got to be day one or not at all.
No.
But it's got to be pretty soon, or not at all.
Okay. And then my other question, which I think the answer is no, is there any authority which either equates or distinguishes between, quotes, reasonable expectation, as it's been used, and the need for an unequivocal statement by words or conduct?
Do you mean in the field of employment law or generally?
I think it would only arise in the field of employment law.
Well,
I mean, but outside employment law, duty to speak, those are familiar
I
concepts.
don't know of. I respectfully invite my Lord to put me right here because I may well not remember or not know. But I don't know of any line of authorities that focuses on the concept of reasonable expectation in the context of employment law in the way that my law obviously does in the context of public law. But there may well be something that equates to it, or perhaps even that phrase. I don't know.
The reason why I ask is that in other fields, there is jurisprudence about the circumstances in which someone may come under an obligation to speak or to so that silence may become unequivocal. It's very, very restricted. Very, very. And I was just wondering whether, because of this concept that I'm less familiar with, of the complex relationship between, whether there's ever been specific discussion of when that sort of slightly different relationship in the employment context operates in a different way from in other spheres.
No, all I can think of off the top of my head is the very famous distinction drawn within employment law since the 1980s at least, between the contractual duty and the duty to behave reasonably, which persists today and ongoing. So both parties to an employment contract have a duty to act with trust and confidence.
Well,
and
To act in a way that doesn't destroy trust and confidence.
It's the duty is a duty not to act in such a way as is likely fundamentally or seriously to damage the relationship
or destroy
trust
the trust and confidence
mutual
relation.
trust.
Yep.
So-
But that is distinguished from
A duty to act.
a duty
reasonably.
to act reasonably. That's the only thing I can.
It's not.
think of.
I don't really think that's
I agree.
pressing my lord's
I agree.
point. I think the truth is, what lies behind my lord's question is a concern. So I shouldn't speak for him about what both Sir Patrick and I said about the ongoing relationship and so forth, and how that fits into ordinary contractual understanding. But Aberhall is the only case really in which that point has been deployed in that context, I think.
Well, I suppose it must have been
We have
deployed
such
at
law,
first
so-
instance in Rigby and Ferodo, but we don't have the judgment. We only have what Lord Oliver says in his speech about the judgment.
Oh, well, we just don't know how.
Yes, I agree.
Thank you.
So can I turn quickly to waiver? I won't take you to the authority. It's entirely uncontroversial that waiver by estoppel requires two things. Again, an unequivocal promise or representation that indicates that the promisor will not act on their strict legal rights, and it's in that context that the quote from Chitty is that mere inactivity will not normally suffice, since it's difficult to imagine how silence and inaction can be anything but equivocal. And importantly also, two, the other party has altered his position in reliance on it, or at least acted on it such that it is inequitable for the promisor to go back on his promise. I won't take you to it, but the reference is Chitty 6-101 within the authorities bundle. The defence of waiver, and I must confess I did get a little lost in the discussion between bar and bench yesterday on this point, but the defence of waiver is, I would suggest, predicated on there having been at the material time no agreement to vary the contract. You cannot waive a right you do not have. So if you're going to waive the right to sue, it is on the premise that you have the right to sue. If you have varied the contract, you do not have the right to sue. I hope I'm not oversimplifying it.
I sometimes thought Mr. Sheldon was saying two things. Implied agreement means that from the time you accept it going forward, the new arrangements involved no facility. But it wasn't always clear for the period up until you had decided to acquiesce whether the rights in relation to that period had gone.
Well, up until, that would be orthodox. So if you had, for the sake of argument, no agreement on day 1, agreement on day 10, you could waive your right to sue on any
days 1 to 9.
damages days 1 to 9. But in respect of whatever period you waive a right, it must be a period in which there has been no agreement. And in that situation, so for whatever period we're talking about, the notion that simply by waiting towards the end of the relevant limitation period before instituting proceedings establishes an estoppel is just heterodox. There's nothing that supports it and everything in every case and commentary that is against it. However, we say that you don't even need to explore that if you, unlike me, think it's less simplistic, because this has to fail on the issue of reliance. My learned friend took you to some passages of the appellant's witness evidence about their willingness to allow PCS officials to sign up members to direct debit. But there are two important points, at least, to make about that. The first is that on any view of that evidence, such assistance did not last more than a relatively short period after the date of implementation, which would mean you would have to have inferred an unequivocal representation on the part of the employees, or PCS, almost immediately after implementation, on which the appellants could then have relied, which we say cannot sensibly be argued for. But there's another much more fundamental problem for the appellants. At no point do their witnesses say or imply that the assistance they provided, and that's the only evidential matter that my learned friend relies on, was in reliance on any supposed waiver of rights. Indeed,
it couldn't possibly be, given what the documents say about the various departments saying expressly, we impose the change, but we're going to try and help you mitigate the consequences.
that is one of three independent, excellent reasons why the argument can't work. The others are this. The majority of the assistance was, of course, provided before the implementation. And the third reason is that the appellants didn't believe that any such rights existed to be waived, and therefore it presumably never occurred to them to consider whether they had been waived. And in short, therefore, there was below, there is now, and there could have been no evidence in any of the cases of the employer relying on any implied waiver of rights, and that's the end of the point.
Sorry, what was your own summary of the point, my lord, put to you, your first point? So there were three reasons.
My lord put to me that on the documents, the reason, the actual factual reason for providing assistance was stated by the employers to be that they were going to assist the unions to mitigate, now my words, to mitigate the effect of the decision to remove Chekhov.
Yeah.
Long before it had even happened, let alone any right existed to waive. And then the other two reasons were that most of the assistance, of course, did take place before the event, which obviously couldn't have been in response to any waiver of rights. And thirdly, and perhaps most starkly, how can you waive, how can you be taken to rely on a waiver of rights when you yourself, the relier, doesn't believe there is a right to waive? And if I may say so, the learned judge in the Smith case sums it up very well at paragraph 97 of the judgment, page 45, but I don't need to take you to it. That was what I was proposing to say on the contractual points. I was now going to turn to the 99 Act points.
Yep.
Now, I was going to make a submission that you may, I hope not find too rhetorical. It is, we say, apposite. This is a classic example of a case to which the 99 Act was designed to apply. Why? First, the contractual obligation was undertaken primarily for the benefit of the third party. That's not always the case. You can confer a benefit on the third party, but the contractual obligation can be undertaken for the other party to the contract. Secondly, the obligation was at no cost to the promissor. And thirdly, the promissor breached the obligation purely to deprive the third party, not the other party to the contract, the third party, of the benefit conferred on it by that term. To make good those propositions, though you're probably deeply enough into this case that I don't need to, the Cabinet Office's own characterisation of the contractual obligation in the letter that triggered all these events, of the purpose of the entitlement to Chekhov, was it is a service to trade unions and their members. And as I said yesterday, every offer letter and statement of terms given to all of the individual claimants included statements that their employer encouraged union membership and valued union representation. My Lord Justice Underhill said, where's the reference in the judgment to that? In Cox, it's a core bundle in Cox, page 98.
Which paragraph?
Paragraph 16.
Thank you.
As with the first claimant, none of the second or fourth claimants holds a contract of employment. They rely on statements issued to them of the summary of their principal terms and conditions. Clause 15 is headed representation and provides there are various trade unions which can support officer reasonable claims and represent points of view. It is, of course, a personal decision whether or not to join a trade union, but we encourage staff to join as an appropriate trade union and to play an active part within it, making sure your views are represented. It's difficult, perhaps, since 2010 to remember the world was not always as it is. This was an employer that actively encouraged for many, many, many decades the collective process, trade union representation, trade union membership. As to the cost of the employer of Chekhov, you've seen that some departments did recover the cost, all were entitled to, and PCS offered to cover them in any case where Chekhov was threatened to be withdrawn. As to the motive, it's self-evident, but anyway, there was unchallenged evidence that the motive was, you've seen, in fact, some of it contemporaneously, it was also in the witness statements of Mr. O'Connor and Mr. Sawatka, to punish the unions for opposing unrelated changes to terms and conditions.
Have you got at your fingertips the reference to the Cabinet Office memo?
It is a source of regret that the actual memo itself, as opposed to quotes from it, strangely is not in any of the supplementary bundles where I can find it. But I can.
Was it in any of the bundles below?
I thought it was.
I'd like to say yes. I'm pretty sure yes.
Well, then there's no objection to us seeing it.
No, it was also referred to in, I believe, the Cabinet judgment. But
Yes, I feel
I can give you a reference within the bundle to a quote from it in the Smith bundle. There's more than one.
Well, I think the sensible course surely is just to get us a copy of it.
We'll try, definitely. And I imagine.
Well, as I say, if using the bundles below, that shouldn't be too difficult.
And moreover, and this was a point that the court established yesterday, the 99 Act was obviously designed to apply, inter alia, to employment contracts. There is a specific part of the Act, section 6.3, which limits its application to employment contract. As well, by the way.
Say, can we be clear about that? You say it was designed to apply to employment contracts. Depends what you mean by that. It was clearly contemplated that it might, or would.
Would. Sorry, that's all I meant.
Could, yes.
That's all I meant. I didn't mean by that the impetus for the legislation was a desire that employment contract.
No, but even that obviously would be an absurd position. That's not what you're saying. But there's an in-between position, which is that although clearly you can see that it was recognised it could apply in employment context, there doesn't appear to have been any profound consideration in the travaux preparatoires, effectively the Law Commission reports, of how it would apply in an employment situation. Well, we are where we are,
but Parliament specifically legislated on the premise, I think I can go that far, that it would apply to employment.
Well, that's section 6 makes your point, and even if it didn't,
and I ought to say, just in passing, because my Lord said yesterday it was designed to apply to commercial contracts, and no doubt that was the main driver. But it was also obviously designed to apply to a whole range of contracts, for instance, made between family members, as in the Bezic and Bezic case, which is referred to throughout the Law Commission report. But in any event, what we say is this: if the Act does not apply in this case, when could it ever apply to an employment contract.
Well, it does apply.
Yes, I mean, I think
applies to
you are inviting us to say you
Yeah.
hope this wasn't too
The
rhetorical.
Act does apply. The question is, what do some of its provisions mean?
Yes.
Well, sorry, my lord. By apply, I meant
It's not going to provide a remedy.
I meant that the section 1(2)(b) hurdle is crossed for the third party. If it is not crossed in this case, in what case will it be?
Well,
But
you
it's been
could have an
conceded.
employment contract in which a payment, the employer undertook to make a payment to a relative of the employee.
And if that had been part of a collective agreement, my lord?
Well, that's my. But you were effectively saying that a collective agreement and a benefit afforded under a collective agreement was the only kind of case in which it could apply. And I was just giving you an example where that wouldn't necessarily be the case.
My lord is
But I wonder whether you said at the beginning you hoped you weren't being too rhetorical. This is very high-level stuff. We've got to deal with the detail of the
Okay.
particular provisions.
But I did want to set the scene because certainly in 1999, if every term of a contract, an employment contract, that purported to confer a benefit on a third party was ruled out, as it were, via section 1(2) on the basis that it derived from a collective agreement and that
Well, always collective in character.
well, collective character might be. I mean, then we get into all sorts of issues about atmosphere incorporation.
Well, quite.
And,
Well,
there aren't many collective in character terms in contracts of employment that are enforceable.
Quite. Well, anyway.
I hear, my lord. I'll move on to the specifics. So, what are the specifics? I should note. I know it's a jury point, but I make it unashamedly. That the defences to the PCS's claims have grown in ingenuity over time. One must remember Kavanagh as well, in which Jonathan Swiftman's counsel accepted that PCS's claims stood or fell on the issue of whether Chekhov conferred a benefit on the trade union. In other words, it was then taken as obvious that there was nothing in the contract between the individual claimants and the DWP, evidencing an intention that the term should not be enforceable by PCS. Now, my learned friend introduced a new argument in Cox. We know what that is. Can I say, it's always been common ground that when the unions and employer had, presumably, we don't know this for sure, collectively agreed in the 1960s, long before third-party contractual enforcement was part of our law, that the employer would provide check-off to its employees. There was no intention that the unions would be able to enforce that collective agreement against the employer. That's always been common ground. But it's now been argued since Cox that this entailed that when that term was agreed as part of contracts of employment, after May 2000, when the Act was in force, it could be inferred, there was obviously no express term, that both the employer and employees intended that the unions should not be entitled to enforce that. And I will address that argument. In summary, we say A, it's a non sequitur, and B, it's a very unlikely proposition. And perhaps for that reason, but perhaps not, a new argument was raised in Crane, which has now been extended to all three cases, to the effect that if the claimants had agreed, the individual claimants, to the removal of Chekhov, then sections 2 or 3 of the Act served to defeat the claim. We say, and there's not much to say about this, other than it's obviously wrong, and that this is assuming against myself that you find that there was consensual variation or waiver. But even if there was. Sorry, consensual variation I'm focusing on now, I beg your pardon. Because even if agreement at the individual level existed, that doesn't bind PCS unless, having assented to the term, it's the words of the statute, which it obviously did, not least because it secured its introduction, then PCS itself, who one of the members of this court pointed out yesterday, I can't remember who, owes the appellants no duty of trust and confidence, has consented to the variation, which on the facts we say it clearly had not. And I just can think of nothing more to say on that point. Mr. Justice Choudhury rejected the argument on that basis in Crane, and it does remain before this court. And then in the final case, Smith, as you know, it was argued for HMRC that the Act doesn't protect the third party's right to enforce if it can be inferred that the promisor did not intend there to be such a right to enforcement, but that argument was effectively dropped yesterday.
Is that the parties party?
Yes. So A11 is section 1, sorry, authorities bundle, page 11. I know you've looked at it many times. I'm not going to read it out again. Obviously, the key part for present purposes is subsection 2. Subsection 1b does not apply if, on a proper construction of the contract, it appears that the parties did not intend the term to be enforceable by the third party. We submit the meaning of that is clear. I noted my Lord Justice Underhill's hesitation about adopting the metaphor of a rebuttable presumption, but we say that is what it effectively is achieved by that statutory language. There is a rebuttable presumption that if a term purports to confer a benefit on a third party, which is now conceded in these cases, it will be enforceable unless, on a proper construction of the contract, a common intention is stated or can be inferred that the third party should not be able to enforce the term. And remember, because I think something different might have been said yesterday, subsection 2 is not confined to implicit ascertainment of intention. Subsection 1b does not apply if on a proper construction of the contract it appears the parties do not intend the term to be enforceable. Could well be gleaned from express wording, though I accept it could also be gleaned from wording that is less than express. Lord Justice Lewis asked yesterday how the Law Commission report had addressed, as it were, the alternative candidates for section 1, subsection 2. Can I ask you to go in the authorities bundle to page 202, because it is somewhat instructive to see what was on offer, as it were. So I hope you'll find there paragraph 7.1, and I think you began to look at some of these yesterday. So ahead of the Roman numerals, the consultation paper sets out 6 possible tests. These were as follows. I'm just going to focus on some. 3, a third party may enforce a contract in which the parties intend that he should receive the benefit of the promised performance and also intend to create a legal obligation enforceable by him, the dual intention test. 6, the third party may enforce a contract which actually confers a benefit on him, regardless of the purpose of the contract or the intention of the party. So those are the sort of extremes. The winning candidate isn't in that list, but if you read on, 7.2, it was provisionally concluded in the consultation paper that the third party should only be able to enforce a contract where the contracting parties intend, that's your third one, above, that he should receive the benefit of performance and intend to create a legal obligation, etc. But then, bottom of that page, in other words, while we continue to believe that one must seek to effect the party's intentions to confer legal rights on the third party, we also consider that to avoid unacceptable uncertainty, one needs a clearer and sharper test for implementing that policy. We have therefore ultimately opted for a test of enforceability which, like the recommendations of the Law Revision Committee in 1937, the wheels do turn slowly sometimes, emphasises the express terms of the contract, but also closely follows the New Zealand Contracts Privity Act 1982 in relying on a rebuttable presumption of an intention to confer legal rights on a third party. So that is the explanation of why they reject the alternatives, clearer, sharper test, the characterisation, the rebuttable presumption, then of course you see the draft words underneath at 7.6, little b. So that's the travaux préparatoire, as it were. Were the learned judges in these cases wrong to find that there was on proper construction of the contract, no mutual intention that the contract not be enforceable by PCS, and I'm aware there are a few negatives in that question.
Just pausing there, I'd also, I'm afraid, been much influenced by reading page 209, and I was thinking of a factual presumption of enforceability. At the very top, the presumption of enforceability and so on. But it's a presumption that the parties intended to contract to confer a benefit. And if that's the case, rather than a presumption that where a benefit is conferred, what might constitute sufficient to rebut it is different. I.e., if the presumption is that they intend, as opposed to where a benefit is in fact conferred, presumption is they should continue to have it, that might throw meaning on the last part of Book 1.2b.
I agree. My Lord actually introduces it at a more apposite point that I was going to, but I was going to take the court to that.
Okay.
So it is at page, for a slightly different point, but or a related point, I should say. So at 209...
Well, it actually starts at 288, so 717 is the first bit that I've just said in the fourth line down onto the presumption is rebutted where on a proper construction of the contract the parties did not intend to confer a right, because you're saying there the presumption is that if the presumption is that the parties intend to confer a benefit, you're looking for things to negative that intent,
exactly,
not
that
a factual conferment.
So far, that's just repetitive of what we looked at 202, 203. Yeah. The bit that I was going to take from 209, and my Lord may well be right to take other useful things from it, but the presumption of enforceability is rebutted where the proper objective construction of the contract is that the parties did not intend the third party to have the right of enforceability. That's the same point. And then it was only this point, really. The onus of proof will be on the contracting parties, usually the promisor, so that doubts as to the party's intention will be resolved in the third party's favour. While we're here, just to save time, although I was going to come to it later, there's the point about the construction industry. And I don't think my learned friend from memory pursued this particularly, I may have forgotten in all submissions, but in the written skeleton we say this is a bad point. The highlighted passage, you may have already read it. We should clarify that even if there is no express contracting out of our proposed reform, we do not see our second limb as cutting across the chain of subcontracts that have traditionally been a feature in the construction industry. For example, we do not think that in normal circumstances, so this is, as it were, on the premise that there is a rebuttable presumption that has to be rebutted, the onus of proof being on the promisor. Nonetheless, they're saying this won't cause a problem. Why? In normal circumstances, an owner would be able to sue a subcontractor. Sorry, we do not think, I beg your pardon, in normal circumstances, an owner, so the promisor, would be able to sue a subcontractor for breach of the latter's contract with the head contractor. Sorry, I should have said third party. The owner would be able to sue a subcontractor promisor for breach of the latter's contract with the head contractor, other contracting party. This is because even if the subcontractor has promised to confer a benefit on the expressly designated owner, the parties have deliberately set up a chain of contracts which are well understood in the industry as ensuring that the party's remedy is
we can read. You can read it. It's an obvious but important point.
Yeah. So where there is such a chain of contracts, which obviously there is not here, the true analogue here would be: could PCS sue its members if they didn't cross over to direct debit for the losses caused? And the answer is obviously no. So
back to section 1, what's going through my mind, just so that one links what I've asked you about with 101. 1A is the contract expressly provides that he may, and then 1B was subject to the term purports to confer a benefit, and we spent a lot of time wondering what purport means. But if you read 1B and 2 together, what it means, although it doesn't say it expressly, the party's intention is that the contract be enforceable by the third party, but if on a proper construction it appears that the parties didn't intend that, then it's not. So 1B and 2 should be read together as being purports to confer a benefit, appears when you look at it at first blush to be intended to be enforced by the third party, but then when you look at it on a proper construction, it doesn't actually achieve that. That's what it's saying. That's why the language of appears and purports are there, because it's not a factual benefit, and that being removed, it's an assumption that because there's a benefit, the intention was that you were going to allow somebody to enforce it, and then you look to the other factors. And that may mean that the collective negotiation point may or may not be important.
Well, my lord, I agree with my lord in terms of purport to. I think that's exactly why it's there. It's effectively connotes the subject to subsection 2 in the preceding wording. I'm bound to say, if it matters, and I don't think it does, that I'm not confident that I can explain it appears that, as opposed to if on a proper construction of the contract, the parties did not intend. It would seem to me to mean the same with or without those words, but I don't think anything's going to turn on it in this case.
Not on appears, purports is more relevant.
Yes, I agree.
But the problem then is, it may be that it is negative because the intention of the parties would not be to confer a benefit on a third party where that third party was the originator of the collective agreement, because the parties would assume and would never intend the collective agreement to be enforceable. That's why when they create the contract having the same benefit in it.
Well,
It's not carrying that over. That's what I haven't got to the bottom of it. That's what I'm struggling with, is to put the two together.
I think, my lord, what I would say is, and I'm obviously, with respect, there's no criticism, but when my lord was expressing the thought in his head, he used the words "the parties" to mean first the parties to the collective agreement,
and then I changed
the parties to the contract employment. It is absolutely essential to distinguish those two, and that's why, briefly, the doubt expressed by the learned academics at the last page of your bundle is wrong, because they don't make that distinction. They treat the parties almost as being the collective parties. This is what we say the principal position is. Acknowledging, of course, as we all now do, that parties means both parties. And it means the parties to employment contracts entered after the 11th of May 2000. In order for the appellants to succeed, they have to show, inter alia, that the relevant employment contracts can be construed, can properly be construed, if you will, so as to infer that at the time they were made, after the end of May 2000, the individual claimants did not intend the check-off term to be enforceable by PCS, because if they didn't intend it, there was no mutual intention.
Hold on, just say that again.
So for the appellants to succeed, they have to show, inter alia, that we say critically, that the relevant employment contracts entered into after the Act came into force can be construed so as to infer that at the time they were made, the individual claimants, the employees, the parties to that contract, did not intend the check-off term to be enforceable by PCS. That is simply to take the language of the statute.
I would not be prepared to accept that, because you're making the same mistake as was made by the appellants before. You've got to, what you're looking for is the intention of the parties as appears from the construction of the contract. You cannot go back to the old canard of saying, well, one party may have had a different idea than another party. You've simply got to look at the contract and say, does this contract evidence or does it appear from a proper construction of the contract that the parties didn't? So you need on the construction of the contract to be able to deduce that the parties did not intend it to be enforceable.
My lord, I entirely accept that. The reason I phrase it in this way is because we're not here construing a term. It's not that we're looking at the contract and deciding whether something that is said about third-party enforceability means this or means that. We are trying to construe, out of thin air as it were, a common intention to rebut the presumption that the parties did not intend there to be third-party enforceability.
Somewhere in the contract. It doesn't have to be.
Yes, absolutely.
Yeah.
It's got to be within the contract, including all the things that you're admissibly allowed to take into account in construing that contract. But if it's not by way of construction of anything that adverts to third-party enforceability, I say that in practice at least, it's going to be impossible to construe a common intention if it is obvious that one of the two parties would never have countenanced it. How can that not
If you look, surely it's much simpler than this. Because it's much simpler than this. You look at the contract and you say, is there anything on the proper construction of the contract which indicates that the parties intended it not to be enforceable? It's as simple as that.
I agree, my lord. And all I'm saying is, in performing that exercise, in this case, you cannot answer the question yes if it is obvious that one of the parties did not intend that it should not be enforceable.
I think that's a very dangerous formulation.
Okay. Well,
Can I say what my problem is? I actually think 1B and 2 now need to be read together. And because I've just been heavily influenced by reading chunks of the law report out of context, I'll have to go back. But I'm wondering now, and I'm really wondering this, that it means the term purports to confer a benefit on him, i.e. There is a situation that the contract between the employer and the employee contemplates a benefit for a third party, and it's presumed that they intend to confer that. And then you look to see anything on the proper construction of the contract to negative that. And it can't be in the contract itself by definition because we're outside that. So you're looking at the circumstances.
Well, it could be within.
Well, it could be, but it may not be.
May not be.
But then I'm asking myself, well, if the situation here is that the benefit accrues to a third party in a situation where the two parties know that that originates in a collective agreement which would not itself be enforceable by the third party, does that then feed into, well, that is the kind of thing that negatives the intention that the individual contract between the parties was actually intended to replicate a situation where the third party couldn't be able to enforce it directly.
Well,
would have it. I'm not putting it clearly.
No, I understand.
Oh,
no, I understand exactly what my lord is putting. It's effectively, my lord, anchoring the appellant's argument in the statutory language.
Yeah, well, I'm obsessed by the language. I think.
No. I mean,
I am too.
yes, I don't want to dissociate myself from such an obsession. All I was saying was that, as it were, I was taking as my starting point what both my lords are saying, and then asking how, on the facts of this case, does one approach the task. And I could, of course, rest, as I do ultimately in writing and will ultimately do orally, on the simple proposition that there is nothing in the contract between the employees and the employer that comes close to discharging the onus of proving that.
Because the other thing I was thinking about this morning on the way in by the tube was this. If this contract, if the employees were employed in 1975 and they'd never changed jobs and done everything the same, there'd be no question of them intending any enforceable benefit, and they wouldn't even have thought about it because the Act hadn't been passed. And then you get to a situation where that person's daughter becomes a civil servant in the family tradition on the 1st of January 2002. Same contract between them, she's doing her mother's job, same terms, everything the same. Has the inception of the Act itself meant the daughter and the employer's intention are now radically different? Or is it a situation where, no, we all know that these things are collective agreements, just as my mum's union couldn't enforce it in 1975, I wouldn't have expected my daughter's union to be able to enforce it in 2002, because that's not the kind of situation where the parties to the employment contract would expect the third party, did you say that's wrong?
No, I say that my Lord has put his finger on precisely the right
The fact that the act has
question.
been passed.
And the answer is yes, of course, the daughter who first turns up at the Home Office in 2002 and who probably isn't aware that there was a collective agreement in the 1960s and certainly isn't aware whether it was enforceable between the parties or not, at a time when the third party's right of enforcement is a part of our legal landscape, to infer then, this is why I kept saying the question must be asked at the time after 11th of May.
But you can't have an answer that varies between individuals depending on their individual knowledge of well, I'm not supposed to passing of the act, that too, but the as it were, employment law background. This originates in a collective agreement and nobody would have thought that the union could enforce it at the collective level. Some will know about that, some won't. I suspect most won't. Sorry, I see the time.
No, I was before I embarked on a long answer.
This is an old conundrum. What degree of knowledge is one really inferring to a particular employee when one's looking at standard terms?
Well, Arnold of Britain is the last, or possibly not the last actually, long line of cases which tells us that you take into account the background circumstances only insofar as they are known or assumed to have been known at the time that the parties entered.
Yes,
but it doesn't let you rewrite or add to the contract. Those are aids to the construction. And the more we're going on this discussion, which will continue outside the door in about a minute's time, it seems to me at the moment that what the appellant is arguing is that in the absence of any other indication in the contract, because there is none, it should be an implied term of the contract that it shouldn't be enforceable.
That's definitely
because the obvious way of dealing with it in an employment contract or any other contract at all would have been to include a simple statement saying this is not enforceable.
Yeah, I mean,
but what you've got to deal with is that these are standard terms applying to tens of thousands of employees and negotiated, although not in a rather unusual way because you don't get proper contracts of employment, at a collective level. And I certainly will want to hear you on whether you're really looking at the assumed background knowledge of an individual employee or of the trade unions who negotiate and produce the individual terms for the individual employee.
Well, between the three of you, you have asked the questions that prompt the next 20 minutes of my proposed submission. So
well, let's have those at from 2 o'clock to
I haven't
20 past 10.
decided anything. I've just been thinking about this on the tube. That's all.
Well, it's a good place.
And walking around the house. And,
Very well. 2 o'clock.